Special proceeding. Special proceedings, as to definition, is a remedy by which a party seeks to establish a status, a right, or a particular fact as provided in Rule 1, Section 3, Paragraph C of the Rules of Court. As to governing rules, it is governed by Rules 72 to 109 of the Rules of Court, and rules on ordinary civil actions applies only whenever practicable. As to basis, it is based on a particular fact, status, or a right sought to be established. As to the nature, as a rule, it is non-adversarial, except when there is an oppositor or respondent. And as to parties, party in special proceeding is the petitioner, except when opposed, the oppositor or respondent. The sources of the rules on special proceedings are as follows. The 1987 Constitution. Rules 72 to 109 of the Rules of Court. BP bilang 129, otherwise known as the Judiciary Reorganization Act of 1980. Republic Act No. 7691, an act expanding the jurisdiction of metropolitan trial courts, municipal trial court, and municipal circuit trial courts. PD No. 1083, otherwise known as the Code of the Muslim Personal Laws of the Philippines. Republic Act No. 8369, otherwise known as the Family Court Act of 1997. The New Civil Code. Rules on Writ of Amparo, or the Administrative Matters No. 07-9-12-SC. Rules on Habeas Data, or the Administrative Matters No. 08-1-16-SC. Republic Act No. 9048, otherwise known as the Clerical Errors Act, as amended by Republic Act No. 10172. Domestic Adoption Act, or the Republic Act No. 8522. Inter-Country Adoption Act, or the Republic Act No. 8043. Arbitration Law, or the Republic Act No. 876. Law on Alternative Dispute Resolution, or the Republic Act No. 9285. Special Rules on Alternative Dispute Resolution, or the Administrative Matters No. 07-11-08-SC, October 30, 2009. Rules on Declaration of Absolute Nullity of Void Marriages and Annulment of Voidable Marriages, or the Administrative Matter No. 02-11-19-SC. Rules on Habeas Corpus of Minors, or the Administrative Matters No. 03-04-04-SC. The Rules on Guardianship of Minors, or the Administrative Matters No. 03-02-25-SC, May 1, 2003. Judicial Affidavit Rule, or the Administrative Matters No. 12-8-8-SC, effective January 1, 2013. Child Witness Examination Rule, or the Administrative Matter No. 004-07- SC, December 15, 2000. The DNA Evidence Rule or the Administrative Matters Number 06-11-5-SC, October 15, 2007. Electronic Evidence Rule or the Administrative Matter Number 01-7-01-SC. Substantive and remedial statute. And lastly, the judicial decisions. The cases falling under the special proceedings are enumerated under Section 1, Rule 72 of Rules of Court. Section 1 of Rule 72 of Rules of Court provides subject matter of special proceedings. The following are the cases provided: settlement of estate of deceased persons, escheat, guardianship and custody of children, trustees, adoption, recession and revocation of adoption, hospitalization of insane persons, habeas corpus, change of name, voluntary dissolution of corporations, judicial approval of voluntary recognition of minor natural children, constitution of family home, declaration of absence and death, and cancellation of correction of entries in the civil registry. In this video, I will be presenting one of the cases under special proceedings, which is the custody of minor child. Documents used in this video presentation were taken from the Regional Trial Court, 11th Judicial Region, Branch 25, Coronadal City, South Cotabato. Special Proceeding Number 585-25 is a case in relation to petition for the custody of minor child named Lay Ann Mel Ariola Cabal, filed by Romel C. Cabal, the petitioner, against his divorced wife, Leia Ariola, the respondent. The antecedent facts of the case. The parties herein, Romel C. Cabal and Leia Ariola, were the previous husband and wife to each other, who begot 2 children, one of whom is Lay Ann Mel Ariola Cabal, the subject of the herein petition. However, due to their irreconcilable differences, their marriage was later dissolved by the First Sharia Circuit Court, 5th Sharia District, Cotabato City, in a petition for confirmation and registration of pronounced talak, entitled Romel C. Cabal Petitioner versus Leia Manzano Ariola, Respondent, docketed as SHCC, Civil Case Number 2008-390, as shown in the order dated July 28, 2009, which was duly registered with the Sharia Circuit Registrar of the said court, and the certification dated April 15, 2010. Pursuant to the order of the Sharia Court in the said SHCC Civil Case Number 2008-390, Lay Ann Mel Ariola Cabal was placed under the custody of the respondent, while their son Romel Ariola Cabal II was placed under the custody of herein petitioner. While the said order of the Circuit Sharia Court placed Layan Mel Ariola Cabal, a minor who is now more than 7 years old, she having been born on June 20, 2004, under the custody of the respondent, the mother. However, petitioner filed the instant petition pursuant to the provision of the second paragraph of Article 213 of the Family Code of the Philippines, which provides, no child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. Pursuant to the aforequoted provision of the Family Code, petitioner seeks the custody of the said minor child, Layan Mel Ariola Cabal, for some compelling reasons, which are the following. Petitioner is an overseas farer with the rank of second engineer and now gainfully employed as such abroad. Respondent has no visible means of income as per paragraph 7 of her complaint affidavit dated March 10, 2010. Respondent has been entangled with and has been made a correspondent in a bigamy case now pending with the Office of the Provincial Prosecutor of Sarangani Province and docketed as NPS doc number X11-07 INV-10E-00119, where the name of Leia Ariola appeared. And to show that Leia Ariola is the same person mentioned therein, her name is likewise mentioned in the counter affidavit of PO1 Abdul Ghani C. Sumangka, the respondent in the bigamy case. In fact, Layan is now appearing very weak and sickly due to lack of proper nutrition, love, and care of the respondent, who often went out at home in Purok Bulak, Paraiso, Coronadal City, South Cotabato, and went somewhere else as she wants and left the child to anybody else at their home. Because of the pendency of the bigamy case, there is great possibility and with all probabilities that the minor child, Layan, while she remains in the custody of the respondent, will be emotionally and psychologically affected as she grown into maturity, as in fact at present, as though she is already suffering from the same. On several occasions, when petitioner visited Layan, the latter has always been intimating her desire to stay with and prefers to be with her father and join her elder brother Romel C. Ariola Cabal II. According to the petitioner, although the council, the foregoing consideration would ineluctably show and prove that it is to the best interest of the minor child Layan Ariola Cabal, both financially, emotionally, and psychologically, to be placed under the custody of her in petitioner, her father. The issue of the case is that is there compelling and cogent reason to award the custody of the minor child, Layan Ariola Cabal, to her father, Romel Cabal? On the court's ruling, the petition is impressed with merits. At the outset, the rule on adoption provides that Rule 99 and Rule 100 on adoption are superseded. However, Section 6 and 7 of Rule 99 do not refer to adoption, but to custody of minors. Hence, they may still be enforced, and decisions of the court on the subject are still applicable. Whether or not the child is under or over 7 years of age, the paramount criterion must always be the child's interest. The sole and foremost consideration is the physical, educational, social, and moral welfare of the child, taking into account the respective resources and social and moral situation of the contending parents. The guardianship or custody which parents exercise over their children embraces the sum of parental rights with respect to the rearing of a child, including his care. It includes the right to the child's services and earnings, and the right to direct his activities and make decisions regarding his care and control, education, health, and religion. The right of the parents to the custody of the minor children is one of the natural rights incident of parenthood, a right supported by law and sound public policy. The right is an inherent one, which is not created by the state or by the decisions of the courts, but derives from the nature of parental relationship. The parents cannot be deprived of such right, except for the strongest reasons and only upon a clear showing of the parent's gross misconduct or unfitness, or of other extraordinary circumstances affecting the welfare of the child. While the law recognizes the right of a mother to the custody of her child, courts must not lose sight of the basic principle that in all questions on the case custody, education, and property of children, the latter's welfare shall be paramount, and that for compelling reasons, even a child under 7 may be ordered separated from the mother. The right of parents to the company and custody of their children is but ancillary to the proper discharge of parental duties to provide the children with adequate support, education, moral, intellectual, and civil training and development. In custody cases, the foremost consideration is always the welfare and best interests of the child. The Convention on the Rights of the Child provides that in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interest of the child shall be a primary consideration. Courts must look into all relevant factors presented by the contending parents, such as their material resources, social and moral situations. Court should conduct thorough trial on all matters relevant to the welfare and interests of the child, and should not resolve cases merely on the basis of psychiatric report and agreement of the parties to submit the case for decision thereon. Whether the parties are already separated, in fact, the need to present evidence in whose custody the child can be better assured the rights granted by the law becomes imperative. The general rule that a child under 7 years of age shall not be separated from his mother finds it raison d'etre in the basic need of a child for his mother's loving care. Only the most compelling of reasons shall justify the courts awarding the custody of such a child to someone other than his mother, such as her unfitness to exercise sole parental authority, The following have been considered ample justification to deprive a mother of custody and parental authority: abandonment, neglect, unemployment, and immorality, habitual drunkenness, drug addiction, maltreatment of the child, insanity, and being sick with a communicable disease. In the instant petition, petitioner has sufficiently presented unrebutted evidence with respect to the neglect, unemployment, and immorality of the respondent. According to him, the reason why he secured a divorce decree against his erstwhile wife is because of his discovery of the illicit affair maintained by the latter with his paramour while petitioner was away working as a seafarer. Moreover, the minor child, subject of this petition, has intimated to her father, the herein petitioner, that her mother is always away and would always leave her alone at home. Moreover, the petitioner is in a better position to provide the material, educational, physical, emotional, moral, and spiritual needs of the minor child that would redound to the promotion of her best interest, because aside from the fact that her father is gainfully employed as a seafarer, the said minor girl would be reunited with her elder brother. On the other hand, her mother, who as earlier adverted to, would always leave her alone at home, is also unemployed. Verily, it is very clear from the foregoing considerations that the petitioner is in a better position to promote the best interests of the minor child, Lay Anmel Ariola Cabal, subject of this petition for custody. Wherefore, in light of the foregoing and for the best and supreme interest of the minor child, Lay Anmel Ariola Cabal, the care and custody over the said minor child is hereby awarded to the petitioner and her father, Romel C. Cabal, and joined with her elder brother, Romel Ariola Cabal II, subject to the visitation rights of the respondent.
Ayan natin ngayon guys kung ano yung child custody, ano yung general rule ng family code, especially sa under 7 years old. Aalamin natin dito kung kanino nga ba mapupunta yung custody ng isang minor, and at the same time, kailan nawawala sa isang mother yung custody ng children below 7 years of age. Sabi nga nila, you may fall out of love, you may end your marriage, pero yung pagiging magulang, responsibility na hindi nag-end. You cannot end your moral obligation to support your children. Sabi ng Article 213 ng Family Code, in case of separation of the parents, the parental authority shall be exercised by the parent designated by the court. Generally, si court yung tumitimbang kung ano nga ba yung mas nakakabuti dun sa bata. The court shall take into account all relevant considerations, especially the choice of the child over 7 years of age, unless the parent chosen is unfit. If the child is over 7 years of age, pwede siyang pumili. However, the court may still intervene kapag yung pinili ng bata is hindi makakabuti sa kanyang welfare. Sabi ng batas, no child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. So, yung default natin guys, kapag yung bata is below 7 years old, sa mother siya mapupunta. Ang reason ng batas na to is to avoid yung tragedy ng isang ina na makwalay sa kanya yung kanyang anak. It's also said that yung pagmamahal at pagkalinga ng isang ina is very critical at those early age, and mas kinakailangan yon ng isang bata kaysa yung paternal care. So, ang general rule natin, a child below 7 years old shall not be separated from his mother due to his basic needs for her loving care. Doesn't mean na hindi na pwedeng i-question ng ama yung custodiya ng isang mother. Tatalakayin natin ngayon kung ano yung mga instances na kung saan pwedeng payagan ang court na ang custody ng isang bata below 7 years old ay mapupunta sa ama. Let's go! Ano-ano nga ba yung mga exceptions natin dun sa general rule? May mga decisions na ang court na kung saan naglahad sila ng mga halimbawa or examples kung kailan pwedeng mapunta sa ama ang custody ng children below 7 years of age. Dito kapag yung mother is insane. Pangalawa, when the mother is sick with disease na nakakahawa doon sa bata which may endanger yung kanyang health and yung life niya. Dahil when it comes to custody, paramount consideration ng court yung welfare ng bata. Third, pag sinabi nating maltreatment, hindi lang yung basta pinagalitan, pinalo, there must be a compelling evidence na maltreated yung bata in order to take away yung custody ng mother dun sa child. Number 4, pag yung mother is engaged in prostitution, kinakailangan dito mapatunayan na yung pagiging prostitute makakapigil sa kanya para maibigay yung kinakailangang pag-aalaga at yung well-being ng bata. Number 5, kapag yung mother is engaged in adulterous relationship, gaya ng sinabi natin, this is not just valid reason na kukunin na yung bata sa kanya, but there must be an evidence na because of her adulterous relationships, hindi na niya kayang ibigay yung kinakailangang pag-aalaga at pag-aaruga sa isang bata. Number 6, when the mother is a drug addict. And kapag siya ay isang habitual drunk or alcoholic, and kapag yung isang mother naman ay nasa kulungan or serving her sentence. So, liliwanagin ko lang guys na yung mga instances na na-mention natin, kinakailangang mapatunayan na inadequate yung kanyang pag-aaruga because of these instances. So, pwede rin ang isang mother may have a history na drug dependent siya or in an adulterous relationship o kaya naman engaged in a prostitution, but pag napatunayan ng mother that she is capable of giving the love and yung care na kinakailangan ng bata, especially yung maternal love, at hindi niya pinapabayaan yung bata, hindi pa rin pwedeng kunin because that is the default. So, In order for us to use these instances, uulitin ko lang, kailangan pa rin patunayan ng father na because of these instances, hindi na ibibigay ng isang ina ang care and custody na kinakailangan ng isang batang musmo.
Yes, I agree with the ruling of the court that the minor child, Leanne Mel Ariola Cabal's custody will be awarded to her father, Romel Cabal. A short video presentation on the rules on how child custody is granted enlightens me that the ruling in the special proceeding case number 585-25 in re petition for the custody of a minor child named Leanne Mel Ariola Cabal between Romel C. Cabal, petitioner, and Leia Ariola, respondent, is impressed with merits. Legal separation between parents and the matters affected by it are one of the most intense and complicated parts of any family litigation. In the case of child custody, the courts take a look into several factors to deem who is the more worthy parent to exercise parental authority, the mother or the father. In the given case, the child custody was awarded to the father, Romel C. Cabal. According to Article 213 in the Family Code, it provides that no child under 7 years of age shall be separated from the mother unless the court finds compelling reasons to order otherwise. This is due to the fact that a mother's loving care is regarded as one of the basic needs of a child. However, the mother will lose parental authority and custody over the child if compelling reasons were found by the court. In the case at bar, the court established that the mother, Leia Ariola, is unfit for the custody of her minor child, Leanne Mel Ariola Cabal, for the following reasons: neglect, unemployment, and immorality. These compelling reasons were the basis why the court rendered a decision that the custody of minor child be granted to the father. In the given case, the petitioner has sufficiently presented unrebutted evidence as to the first compelling reasons, which is neglect. The petitioner has presented evidence that her previous wife neglected their child through his statement during the hearing between him and his counsel, Attorney Sardido, as supplied. As to unemployment, the petitioner has sufficiently presented unrebutted evidence which is stated in her counter affidavit dated March 10, 2010, paragraph 7, that she has no visible means of income and that she and her child totally depends on her ex-husband allotment. And lastly, immorality. According to the petitioner, the reason why he secured a divorce decree against his erstwhile wife is because of his discovery of the illicit affairs maintained by the respondent with his paramour while the petitioner was away working as a seafarer. Supplied are the facts during the questioning between the petitioner and his counsel. Also, one of the evidence presented by the petitioner is the pending bigamy case wherein the respondent was entangled, appearing that the respondent and the person mentioned in the counter affidavit of Police Officer 1, Abdul Ghani Sumangka, is the same person involved in the bigamy case. The court also give emphasis on the capability of the petitioner being a seafarer earning a salary of more than $7,000 or roughly 300,000 pesos converted in Philippine currency, is in better position to provide the material, educational, physical, emotional, moral, and spiritual needs of Layan Mel Ariola Cabal. Aside from the fact that he also has the custody of his son, Romel C. Cabal II. Hence, with all this unrebutted evidence presented by the petitioner, I am amenable with the court's ruling that the minor child, Layan Mel Ariola Cabal, will be awarded to her father, Romel C. Cabal. It is very clear from the foregoing considerations that he is in a better position to promote the best interests of the child.